Our first speaker really is Andrea Charters. She's going to tackle at the front end really IT and patent troll issues. At the back end, we'll be talking a little more with our friend and colleague Neil. He'll be tackling on the life sciences, bio, and pharma space for their exposure to patent troll litigation as well. Somewhere in the middle there, I'll be talking about sort of my bread and butter in what we do for consulting purposes is help companies keep their costs down and extend their litigation spend budgets. Very often, this is a difficult proposition when you're talking about large-scale IP litigation, but we'll have some tips and tricks that we've come up with that we hope are useful for you as well.
Matt, ball is in your court to ask me about this.
Certainly, and obviously we'd like to get your experience and your insight into sort of a little more background into the patent troll phenomenon, how it really started, and really how it affects both IT and life sciences. Does it affect it differently?
Well, it does. We could move to the next slide and we'll show the audience some of the history on this. The whole concept of patent troll started out with the Associate General Counsel of Intel needing to have a term that could be used without casting aspersions on the patent troll companies that were suing Intel. And basically, these companies had been trying to monetize their patents by going after companies, particularly in the IT space, such as Intel in the late 90s, by trying to sue for the value of their patents against companies that were using other types of patents for intellectual property of companies that had software businesses in particular. And the intrinsic business of litigating and licensing patents are very closely intertwined, as we'll see conceptually. Basically, this Associate General Counsel of Intel, Peter Detkin, subsequently has become accused of becoming a patent troll leader himself, which is kind of ironic. But conceptually, it's difficult to tell when a patent should be considered just simply a patent and when it should be considered an offensive weapon by a patent troll. Basically, Peter Detkin could not continue referring to patent trolls as patent exploiters. He had to come up with a more vague term, so he coined the term patent troll. We can move to the next slide now, Tom. Conceptually, these patent troll cases often proceed on invalidating the patents that are being asserted, because there are many sticky questions about the validity of the patents, and the PTO does not get overturned lightly. As a rhetorical question, how do you distinguish a valid patent from a patent troll situation? Can you say that simply because a company is a non-practicing entity, which is the more technical term for a patent troll or a patent assertion entity, that they should not be able to enforce their patents? We can move to the next slide again. This is a procedure versus result issue. A university as well holds a lot of patents that they're not using. Some large companies hold a lot of patents that they're not using as well. How can we say that legally simply not happening to use the patent at the moment is a reason that one can't sue to enforce it? The issue is that some companies design a strategy of amassing a whole bunch of patents to start going out to sue prospectively without doing any business at all on anything, and go out to amass the patents from other businesses that developed them in the first instance. And we'll see as we go along that the validity of the patent becomes a key strategic issue in these lawsuits, and one that in the software space in particular is problematic because of the functionality arguments that can be raised in the information technology area. So if we move to the next slide, Matt can ask me a little bit more in detail about how this plays out.
Sure. Well, because we do what we do on the litigation support and consulting side, we see a lot of different types of cases, but we don't always see, IP specific or IP only cases. What's really the exposure out there? I mean, how many of these cases are actually being filed, Andrea?
Well, we can move to the next slide and we'll have the visual for the audience. Right now, in the patent area for this year, 67% of cases are brought by companies that can be considered to be patent trolls, some type of non-practicing entities. This is coming from a PricewaterhouseCoopers study. And there are terms for these companies: non-practicing entities, NPEs, patent assertion entities, PAEs. And the dollar amount of the claims are sometimes in the hundreds of millions or even $1 billion. And settlement amounts are generally undisclosed, but can in some cases be substantial. There's a conceptual and a strategy issue here. And we can move to the next slide and look at some of the conceptual issues. The software space is particularly problematic because there's not a simple smell test of whether a patent is valid. The devil is really in the details, and it goes to the ability of both the adjudicators at the courts, the juries, and also the attorneys involved in the litigation to be sophisticated enough to understand the scientific issues, get the information out of the engineers, present it in court effectively, and slog away on whether a patent is valid or not in a way that is understandable to people who are not scientifically trained, in the court personnel, and if a jury is called in front of a jury. And there can be jurisdictions that we'll talk about later on, like the Eastern District of Texas, where local court rules make it particularly easy to get a jury in a patent trial, and that will tend to add to the potential damage award if a jury can be called. And there are rules that allow such favorable treatment of patent troll cases in some jurisdictions, in particular the Eastern District of Texas, that companies that seek to amass a number of patents to be non-practicing entities will, in some cases, locate themselves for an advantage in personal jurisdiction and venue arguments in these jurisdictions so that they can particularly go at it. And we'll discuss a little bit more of the really ultimate questions of why the functionality issue in software cases is particularly problematic. If we could go to the next slide, we can talk about how this plays out a little bit further.
Exactly. And I did want to see if there was a different treatment for patent trolls or the exposure for IT or tech patents in the software area as opposed to in the biopharma or the life sciences area that we'll hear a lot more from Neil about later. I mean, is there the same sort of exposure from patent trolls, and what would be the factors that would stop one side from being attacked more?
Well, the answer to that is about a 75% there. Yes, there is a difference, and there's about a 25% there are some concerns for both types of companies. If we could move to the next slide, I'll get into some of the details here on the tech space. it's generally thought that the biopharma patents are somewhat less vulnerable and less problematic. And there are some coalition issues that have put biopharma on the side opposing patent law changes that would aggressively limit patent lawsuits. But this is largely for historical reasons, as we'll see. And there is one key conceptual reason in the difficulty of asserting IT tech, particularly software patents. And we can move to the next slides and start looking at these. But the issue here is not exclusively that it's difficult to have a software patent. There can also be issues where there could be some needs for holders of biopharma patents to try to monetize their patents in a way that could, in the end, somewhat loosen this coalition. So there's an aspect, if we move to the next slide, slide 17, on IT tech patents, of functionality, where the key issue here is the difficulty of separating the function of the device from the means of producing the function. This is a functionality issue. IT patents simply are very difficult to define, and in some countries, even major WTO, World Trade Organization, TRIPS IT patent cases are simply not possible to bring because IT patents are not available. Some people would say that IT should become obsolete as a way of enforcing new technological changes, or should be protected as a trade secret, and shouldn't be so heavily protected by patent law. We can move to the next slide and we'll talk about this in the context of TRIPS.
And of course, that begs the question that, you know, we can't really look at patents in a vacuum just from a U.S. jurisdiction standpoint. Are these treated internationally in a different way, and how have they dealt with the patent troll issue in say, TRIPS member states?
Well, in TRIPS member states, it's really all over the lot. We can move to the next slide. There are some states that protect IT patents in a manner similar to the U.S. There are others that have weaker protection, and there are still others that don't provide protection at all. And there are 10 of them who are sufficiently major countries to belong to the TRIPS agreement who don't have any protection on IT patents at all. So the reason I underscore this issue is twofold. Partly it's a north-south and a U.S. versus non-U.S. issue, where the U.S. would like to be protecting its innovators with patent law, and many other countries around the world are much more even opposed to this idea because they see it as something that gives the U.S. an unfair advantage. But it also secondarily underscores just how problematic it is to deal with this functionality question when there is such a legitimate argument that you shouldn't even have protection for these software patents. There's a question of the appropriate way to protect IP and the competitiveness of U.S. industries. And it can be played out in international arenas where people can continue to belong to international organizations like TRIPS and the larger WTO without enacting the local legislation to enable protection of software patents. So we can move to the next slides and start talking about how some of this plays out in U.S. arenas as well.
Exactly. I mean, obviously, the patent organizations, PTO, WTO, you know, obviously they're going to have their imprint on this, but can anything be done, or has anything been done legislatively, either at the federal level? Have the states gotten involved, and is there anything else that other federal agencies are going to speak to really sort of wrangle this issue?
Well, we can start moving through the next few slides and we can address this. Yes, this is being tackled at every level of the U.S. government, basically. In Congress, it's a question of the America Invents Act versus the Innovation Bill. And in May, a couple of months ago, another piece of legislation was shelved, primarily at the initiative of Senator Leahy from Vermont, where universities and others, partly from the Biopharma Coalition, were opposed to the efforts to make it more difficult to sue as a patent troll. And it comes back to this conceptual issue of separating out what is a good patent. And in the legislative arena, it was put on the America Invents Act from 2011 rather than starting further legislation in order to try to have long-term patent reform under the America Invents Act. And also through the court system and through state attorneys generals and the FTC. And basically, there are many good reasons, good and valid reasons, why there was opposition to having additional legislation that would have made it more difficult to bring a suit as a patent troll and to toss this into the court arena. So we can move to slide 22, and we'll look at some of the things on why state AGs and the FTC have been also involved, and why this is really a lawyer's question. We can move to slide 23. The state AGs and the FTC look at this as consumer protection, and they've taken positions generally against patent trolls, partly at the request of Senator Leahy, but this is a consumer protection issue, and we're back again to implementation and living under the regime of the America Invents Act for issues of the quality of patents. And to play this out in the court system, there are a lot of issues for attorneys. We can move to the next slide on the Supreme Court. So this is an area where there are substantive issues and there are issues in terms of attorney's fee awards. We can go to slide 25. There have been really 4 cases at the Supreme Court and 1 piece of progeny from the Supreme Court that just in the last few months that have been pivotal in this area and that we need to inform ourselves about. Alice Corp v. CLS Bank involved a patent on technology for financial transaction software where there was a 9-0 decision authored by Justice Thomas that had very powerful agreement by the Supreme Court justices that a patent involved a, quote, idea, not an application of an idea. And this harks back to the early 2000s and the fundamentals of patentability. You can't get patent or other intellectual property protection on things that are just ideas. PTO instructions to implement the scope and extent of this holding did come out on June 25th, very quickly. And there is already some progeny on this case from July 11th, a couple of weeks after the Alice Corp case, where Digitech involved invalidating a patent. Well, when you get to the case of invalidating a patent, you really are doing lawyers' work because there are many issues that we'll discuss in another slide or two that talk about why you have to get beyond just a recitation of having an application of an idea. It's not that simple to just throw in some additional language to protect a patent. It's essential to have some key detailed implementation of the structure of the machine that's going to do the work in a software application. And then there was an additional Supreme Court case called Limelight Networks v. Akamai, where inducement was found only if there's direct infringement to be a substrate on the layer of infringement. And that was another 9-0 decision where Justice Alito was the author of the opinion. And these two opinions arguably make it much more difficult for patent trolls to successfully sue. But getting these cases to go through the courts and actually become the law of the land is going to be a little bit more complicated than just saying, okay, we have Alice Corp and Limelight Networks. It's going to take time to say, okay, what do these cases really, really mean once they go to the circuit courts and the district courts? We can go to slide 26. The PTO guidance that came out on June 25th suggests that the structure of the technology is critical to having this term, that you're not just having an idea, you're having an application of an idea. And you have to implement this with some kind of unusual functions, a machine or transformation test, to become something more than a generic computer. So you can't just change a word here and there. You have to detail it more in work that involves interaction between the attorneys and the engineers and other scientists who have come up with the patent in the first place. And the conclusion is that software is still patentable in the US. It's not like some of these other TRIPS countries where you can't even get a software patent. But it's not clear where the courts are going to go once all these cases are brought. We can go to the next slide. The other issues are attorney's fees, because in order to get attorney's fees in a patent case, one has to show under the statute that there are exceptional circumstances to get an award of fees. It's not simply an English rule on having attorney's fees in patent cases. There are two cases that came out, Octane Fitness v. Icon Health and Fitness, that interpreted the exceptional standard in a way that makes it easier to get awards of attorney's fees, and Highmark versus Alliance Health Management Systems, where the standard of review over lower courts will be an abuse of discretion. And that means that lower courts are more free to award attorney's fees and not have their awards overturned on review. So the effect of these cases is that patent trolls face fee awards that could be very game-changing to their litigation strategies. We can go on to slide 28.
And you mentioned that before regarding Texas.
Yes, yes. We can take a look at the next couple of slides here, slide 29 on jurisdictions. This is exactly what I wanted to foreshadow, where non-practicing entities will actually go to this rural district of the Eastern District of Texas, which makes it difficult to defeat venue, and locate their offices there so that they can really bring the suits in this district. And there's not much chance to defeat personal jurisdiction. We can move to the next slide. It's going to be very, very difficult to get out of the Eastern District. But at the same time, we have to consider the way that federalism really works. because with these attorney general actions, people also have to deal with Vermont because most companies in the U.S. are operating in all 50 states. You can't really say, I'm not going to sell to people in Vermont or I'm not going to do business in Texas. This causes dilemmas and potential whipsaws in a way of trying to be out of different legal regimes. And this is going to change the strategy for patent trolls. We can move to slide 31.
And that is often the case. You'll have multiple defendants, and is there some sort of strategy that's applied by patent trolls to multiple parties that they're suing?
There indeed is. We can move to slide 32. The game theory strategy of a patent troll is to see who is going to swerve first to avoid a major loss. And their strategy is to get some small settlements from the weakest defendants, often startup companies, to try to fund larger lawsuits. We can move to the next slide. The multiple defendants raise the traditional issues of having a number of defendants in a lawsuit, and it's really a question of who's going to cave in settlement, who's going to fund the lawsuits by the smaller players, getting cooperation among the defendants, and putting a premium on the question of attorney's fees and the patentability questions and the validity of the patents. It also puts a premium on the pool of tech-savvy legal personnel. So this is where I'd like to tee up Matt's discussion, where he's going to address how people can kind of try to circle the wagon train to deal with the litigation. Matt?
Thanks, Andrea. And that does segue nicely into what we want to talk about. Really, the exposure that very often isn't necessary when you have a non-practicing entity attacking an innovator or somebody that is attempting to roll out new technology that is necessarily going to be an expensive proposition in litigation. The practical implications of patent troll initiated on the legal spend is significant because more than anything, it's very much data driven. And as we know with whatever corporate clients or if we are a corporate entity ourselves, we know that there's an explosion of data out there that is readily available for litigation purposes. It's not just email anymore that's being attacked. We see document requests for SharePoint, social media as well, Facebook, LinkedIn, where folks might discuss some of these issues as well. And it goes all the way to companies moving into cloud storage structures, which are traditionally a little difficult to get data out of for litigation purposes. A well-informed patent attorney really knows where to look for that data and of course knows exactly how much it's going to cost the defendant in that case and use it rightfully to his advantage in his litigation strategy. Despite the fact that there's several proposed federal rules of civil procedure related to e-discovery, they don't really speak to specifically this area. So there's not going to be a real bit of comfort or relief when it comes to e-discovery. We can move to the next slide. And this next slide is what I like to call the big scary slide of data, because this sort of really puts a face on just how much data is out there and what is available, especially in a data-intensive litigation like IP litigation. Corporations are manufacturing data at an unbelievable rate. And it's very possible that some of it, or a good portion of it, is going to be needed to be preserved for litigation purposes. This is probably truer more so in IP cases than any other case. There isn't a lot of data that can be generated in the prosecution of a patent or defending a patent that you'll be able to get rid of in your normal course of business or in your document retention and destruction policy. Folks really just don't throw away their IP-related data, so it piles up. The next slide, please. And whenever it does pile up, it gets expensive to deal with in litigation. These are based on average industry prices for dealing with data in its raw form. Just to collect, process, and host 1 terabyte of data could expose a company to anywhere from $280,000 to a little over $600,000 per year. If that data needs to be reviewed for IP litigation, well, you can see at the bottom there, you're looking at well over $3.5 million just to review that terabyte of data. It adds up fast, and the data adds up even faster. So we try to stay ahead of this by making the data work harder for us. Next slide, please. What we try to do is, when working with our clients, we try to create a repeatable process. As much as possible, if we have the ability to repurpose data, say a client of ours has to defend the same patent several times in serial litigation, what we like to do is have that data processed once, reviewed once, produce it many times. So you're not going to have to go back and look at a document again for privilege purposes. You just need to know whether it is responsive to your case with your search terms or your culling strategy. So in that way, we make the data work on multiple cases, and they're not having to pay the extra expense of review. Once we've reviewed that data, we can mine it for all that information that the attorneys have added to those documents. The issue codes and the things that are going to be useful for the next litigation can be useful and stored for that client to be used case over case. And even more importantly, what this really begs the question is, do you have partners that know your data, that know you as a client? And that can really only be done by working with folks that work on your data case over case, or have the ability to have the same attorneys know your technology, know your patents, and be able to apply that knowledge to the next case that comes in the door. But some of the things that are necessary to do up front is to know your own data. Work with your IT folks and your legal folks in collaboration to be able to be responsive to those document requests, to be able to know where to find those important custodians and that data that you need to produce or preserve for that litigation. Have a good document retention and destruction policy in place. Even though it doesn't really necessarily help or apply in an IP situation, because more than likely you're not going to be destroying much of that data, if any. There's other data that for risk management purposes you might not want to sit on and expose yourself to further litigation. And that goes back to having a good data map as well. Knowing your data, knowing exactly what you need to do to get the documents to your outside counsel, and to have a responsive, collaborative IT and legal relationship to drive litigation is always going to help lower your litigation spend. Next slide, please. And hopefully that segues into what we like to talk about with our friend and colleague Neil Belson as it relates to the life sciences side of things. We mentioned, and we talked there earlier with Andrea about the IT exposure for patent trolls. So we'd like to talk with Neil Belson about life sciences and biopharma and exactly how those folks are affected by the patent troll phenomena.
Thank you very much, Matt, and thank you, Andrea. And so, yes, I am here to speak with you about patent trolling and its impact on the life science industry. And the short answer is the life science industry experience different from the IT's experience with patent trolling is emphatically yes. The short answer is that patent trolling has had much less impact on the life science industry, at least to this point, than, say, IT. And a lot of life science companies, in fact, are under the assumption that this is not really a life science industry problem. However, there are certainly several areas of risk where life science companies could actually face potential exposure or vulnerability from patent trolls. So I'd like to first of all go over why the life science industry has had such different experience Anyway, I'll let you ask the question, which is right here, Matt.
Certainly, yes, absolutely. And why is that? Is there specific reasons why? Is it a cost issue? Is it development time? Is it just not feasible for patent trolls to actually tackle that industry?
So the answer really is some of all three. First, and I think perhaps the single largest difference in the two industries' different experiences has been that a lot of life science products, especially drugs, which are the new drugs, are based on often a single patent, can cover a blockbuster drug or perhaps a few patents. This contrasts with with the technology industry, where new technology, new IT applications may be based on dozens or hundreds of patents, each of which has a narrow part. Here there's just a couple, so and they're very specific. They're not. It will define a particular compound. The key patent that will protect a major drug may just be a single patent that defines a particular kind of chemical or use of that chemical and a few different types of chemicals around it. And it is much more difficult to attack than a product that's supported by dozens of patents, where all you have to do is find one or two of those patents where you could find perhaps basically one or two infringing claims targeting only one or two of those patents or one or two of the features of the application. And so another thing to keep in mind is that before a pharmaceutical company even starts its development of a new drug, it will do a very comprehensive review of the patentability of that particular drug compound that they're looking at. And no matter how well it works, a particular drug, it's unlikely that a pharmaceutical company would try to take it through the regulatory approval process and into commercialization unless it felt comfortable that it could get a strongly protected patent on that new drug candidate. And there's several reasons why patentability is so carefully reviewed up front before a pharmaceutical company even attempts to develop a new drug candidate. First and foremost, drug development is very expensive. It costs, and this is an estimate, and I hear it varying several $100 million one way or the other in different cases. But it's a safe statement to say that it could cost $1 billion and take 8 to 10 years to develop a new drug from the time that it's first conceived to the time that it's successfully approved by FDA. And it's also important to keep in mind that most new drug candidates fail. Just to give you a sense of how difficult it is to develop a new drug, it's estimated frequently that of every 10,000 compounds, chemical materials that are randomly tested, only one of those 10,000 will 8 to 10 years down the road or more become an approved commercial new drug. Even for drugs that make it a significant part of the way, compounds that show some promise in the early test, compounds that are even approved to start pre-commercial testing in humans, I would say only about what I've read is 1 out of 10 perhaps of those drugs that are actually approved to start testing in humans ultimately succeed in becoming drug candidates. So these enormous cost issues are why companies are so careful in investigating the patentability of their candidates before they start to try to commercially develop it. And it's also an explanation why no matter how effective a new drug is, if they can't confidently get patent protection for it, that cannot be challenged by third parties, they're probably not going to try to commercially develop that drug candidate.
Please pardon this interruption. I'd like to take a moment and announce the first CLE code. Attendees, please take note. The first CLE code for today's webinar is 3551. Again, the first CLE code is 3551. Thank you, Neil.
Thank you, Kathleen. And actually, I'd like to break in as well. I just saw a terrific question come through that sort of speaks to what Neil was just talking about. David asks if they do research, if they do their search before really entering development, how do they protect against competitors racing to get the same compound protected?
Well, that can be a, that is a risk. That it's possible to, that there may be, when they're doing their initial research, it is certainly possible in the months before a patent application is published, somebody may theoretically be researching the same drug compound. How likely is it that someone's researching the same compound out of all the possible compounds? I don't know. Probably not. It's not necessarily likely, but it's certainly not impossible, or something sufficiently similar would be covered by the same compound. So there is maybe now patent applications are normally published if you go through the very common international, what's called a PCT route. They're often published 6 months after they're first filed. So I guess in that 6-month window, there is the risk that somebody might have gotten a patent application on the same compound filed before you. But you would know it within the first 6 months when you're still in very early stage. And most of the, and once you've gotten past that 6 month stage, you would know if somebody had a patent application on the identical material, and yours would probably get bounced. So you wouldn't be too far into the development process by the time you found out.
Oh, terrific. Thank you. And now you mentioned that traditionally life sciences really hasn't been exposed to patent troll issues. And you also mentioned that people in the life science area don't really think this is necessarily their fight. Is there a possibility that could change in the future?
Oh, absolutely. And I'd like to just highlight 1 or 2 items on this current slide, just to give you a lay of the land of the FDA or the pharmaceutical industry, and then I will go right to your point, Matt. Okay. Another thing to keep in mind here is there are also regulatory barriers for companies to get into this field. You can't just make a few changes to a drug and design around a patent as well, because once you start tinkering with the chemical compound that forms a drug, you've got essentially a new compound, and it's unusable unless you separately go through the same FDA new drug approval process and incur that $1 billion and 10 years of research. Might be a little less if it was very similar, but basically you've got a new drug candidate on your hand and a lot of expense in front of you. You're pretty much bound. Once FDA approves a particular chemical for a particular purpose, that's the approved chemical, and once you start changing it, it's a new chemical and no longer covered by the FDA's approval. Okay, I'm sorry. Now I can get to your question, Matt.
Okay, no, absolutely. Yeah, I mean, is there any thought to future exposure for patent trolls in the life sciences area?
Yeah, absolutely. Now, I mentioned how carefully companies review the patents that protect their drugs, and they do. There's a whole lot of other patents that can come into come into play as well regarding a new drug patent. There might be patents around the methods of making the drug or mixing the drug with other materials, inert agreements because that are part of the compound, how you mix the drug with the other materials that are going to be part of the pill or capsule that eventually is going to be used, and those may be able to be designed around or replaced with other methods of manufacturing. And then there are things called methods of treatment. For example, if you have let's just say hypothetically a drug for the treatment of Alzheimer's disease, your patent application may include claims that protect, quote, a method of treatment which involves using your drug to treat arthritis. So you've got methods of treatment claims as part of your patent. And it's a safe bet that the patents that sort of surround the product, the ones regarding its method of manufacture, which may not have even been fully developed when the first patent on the drug itself was created, those are probably less extensively reviewed. And while it's very difficult for a couple of inventors in their garage to develop a commercial drug blockbuster in their garage, as sometimes could happen in the IT industry, it's a lot less expensive. It's a lot less expensive to develop and also take to commercialization a method of manufacturing or formulating a drug product. So there's a much broader, less carefully reviewed universe of patents around the drug patent. Also, and this is just like the IT industry, there is a universe of unused patents that that may exist. For example, many biotech companies and sometimes pharmaceutical companies have a large number of patents that they're not using. They may have developed them because they related to lines of research that have been discontinued, for example. And universities, as has been previously discussed, also have large portfolios of unused patents. And I just want to state another risk comes from the area that lawsuits might not be limited only against the pharmaceutical company. Rather, they can extend quite broadly beyond the pharmaceutical company. For example, I mentioned method of treatment claims. For example, treatment of arthritis using the particular drug. Well, let's say somebody thinks that they own a right to a method of treatment that the pharmaceutical company has or drug company hasn't adequately protected. Somebody thinks they have an infringement on some treatment method. They could sue suppliers and contractors who make the drug for that purpose. They could sue pharmacies that use the drug for that purpose. They could sue physicians and even patients who are prescribing and using the drug to treat that particular disease. So it's not only the pharmaceutical company itself, but the entire universe of suppliers, distributors, and users of the products for the particular purpose that could be at risk if a troll is able to capture an allegedly infringing patent on perhaps a method of use. Now, in this regard, I want to point out the Association of University Technology Managers, which is a university trade association that basically is in charge of trying to commercialize university technology by licensing it to the general public. In 2007, they put out 9 points to consider in licensing university technology, guidelines that university should follow and in licensing. Now, many of them were unrelated to the patent trolls, but as you can see, part of point 8 specifically stated that it would better serve the public interest to avoid companies that rely as potential licensees, to avoid companies which rely primarily on threatening litigation as their primary source of revenue. In other words, the AUTM recommended against licensing to patent trolls. And at that time in 2010, a dozen signatories, including some of the country's most prominent research universities, were signatories to those 9 points to consider. And since that time, you could go to the website listed on that slide, and you would find that the number of signatories is quite a bit larger since 2007. Now, there have been some reports that AUSTM is actually contemplating changing this point date because some license offices and some universities are that starved for revenue that they'll go anywhere. However, from what I've been able to read, it seems like AUTM and the industry, the university community generally disputes those reports, and as far as being willing to amend that point. I should also point out, with regard to the patent trolls, there are reports that some pharmaceutical companies and biotech companies are taking their unused pools of patents and actually initiating contact with patent troll companies, and whether or not any major deals have come, I don't know, but certainly there are reports that some of the pharmaceutical companies and others are looking to monetize or get rid of their unused patents in a way that will make them money.
Well, Neil, of course, licensing is such a big part of, especially life sciences and biopharma. The interpretation of those licenses, when people are coming up with different methods of manufacture or as you said, methods of use, have to be interpreted as being outside those licenses. Is there any recent case law that you could discuss about those points?
Oh yeah, some cases, and in particular in this one, I recommend that everyone who's listening in listen to this first one extremely carefully. It's an outstanding example of how a few words can have drastic impact. And in this case, I would say has completely changed the way licenses are, or at least should be worded, with respect to the issue it addresses. Basically, there was a scientist at Stanford University who signed a standard employee, as many employees in many companies are required to do, assigning ownership to the university of anything they happen to invent while they're employees. And basically, the employee's standard contract, the scientist said that he agreed to assign any inventions he might make while a university employee and using university resources to the university. Later on, that same professor had some discussions and some interaction with a private company, Roche, and signed a document stating that he does hereby assign any inventions that comes out of it. So basically, Stanford's agreement came first. But it said agrees to it, that the employee agrees to assign his inventions. The private company's agreement came later, but said that the employee or researcher does assign any inventions, or does hereby assign any inventions. So some years down the road, after the research led to a profitable invention, Stanford sued Roche for infringement. And what the court decided was that even though Stanford's agreement came first, an agreement stating that an employee, quote, agrees to assign is merely a future promise to assign your inventions to your employer. That language, agrees to assign, does not actually assign anything to the university. It just gives them a contract right to demand assignment later on. In contrast, the company's language, that the inventor hereby assigns any inventions, does affect an immediate transfer or assignment to the company, even with respect to future inventions. Something that says, I hereby assign anything I invent while working for you, immediately assigns your right, even for future inventions. So basically, the court said that even though the company came second, their contract immediately assigned them rights, whereas Stanford's was just a promise that some future act would come later to assign rights. And since there never was a follow-up assignment, Stanford didn't have any ownership to the employee's rights, so Stanford had nothing to sue on for infringement. So the important takeaway from this is when, for example, you're writing license agreements or any employment agreements with employees who are going to be assigning their rights, always, always, always say the employee hereby assigns any rights to any invention while an employee to the company. Do not write employee agrees to assign. That does not transfer the rights unless there's a follow-up assignment agreement by the employee. And I would say up until that point, I'd say a lot of companies and lawyers assumed it really didn't matter. They used the two interchangeably, but not after that case. This case, Preston versus Marathon Oil, is sort of the inverse of the last time. An employee, Preston, signed an agreement with his employer stating that he, quote, does hereby assign all intellectual property that he developed while he was an employee. At some point subsequently, there was a falling out between Preston and his employer, and the employee became uncooperative. Anyway, the court said basically that language is in his employment agreement, that the employee does hereby assign his intellectual property to the company that he developed while an employee. That in and of itself was sufficient to automatically transfer rights to any future inventions while an employee, even if the employee later refused to sign formal assignment forms. Basically, this case, as I said, is the inverse of the last one. So Marathon Oil basically did it right. And no further action was necessary by Marathon Oil after the employee agreement was signed in order to acquire rights to what the employee developed as an employee.
Please pardon this interruption. I'd like to take a moment and announce the second CLE code. Attendees, please take note. The second CLE code for today's webinar is 521. Again, the second CLE code for today's webinar is 5212. Thank you, Neil.
Sure. Okay. Abraxas versus Navinta highlights another thing to watch out when you're doing license agreements. In this case, there were really two issues here. First of all, it said that the seller in a purchase agreement, quote, shall cause its affiliates to transfer patents to the purchaser. Now, as you may guess from the previous two cases, a contract that merely says that the seller shall transfer patents or shall cause its affiliates to transfer patents was not sufficient by itself to actually transfer patent ownership to the purchaser. And there has to be, if you use that language, shall transfer or shall cause its affiliates to transfer, then there has to actually be a separate document that actually does the transfer. That language by itself doesn't do the entire trick. Furthermore, in that case, the patent owner pre-agreement was not the parent corporation that signed the deal with the purchaser. It was the parent subsidiary. So the parent had, even if they had written the correct language, as in hereby transfers, the parent had nothing to transfer. Even between a parent and its wholly owned subsidiary, if the wholly owned subsidiary is the official owner of those patents, then an agreement with the parent alone is not sufficient to transfer the patents. There has to be, even between a parent and its wholly owned subsidiary, a separate assignment agreement transferred before the purchase, transferring the ownership from that subsidiary to the parent that's actually doing the deal. And so these are both important points that if you're doing license agreements, you need to keep in mind that A, the agreement actually covers the owner, the purchaser or transfer, or the seller or the transfer of the patents has to actually itself, that corporate entity, must actually own the patents at the time of the deal, and the language should state it actually hereby transfer those patents as of the time of the deal. And because it failed in both respects, the plaintiff had no title, acquired no title from that deal to the patents, and therefore could not sue for infringement. And the court also held that at some point after the plaintiff had filed its infringement lawsuit, it and its previous sellers entered into some sort of purportedly retroactive transaction to try to cure that problem. And the court said failure to own a title at the time of an infringement action cannot be retroactively cured. Basically, you don't own a title at the time you file the lawsuit, you cannot file for infringement. The one exception to that is an assignee may sue for past infringements if the assignment agreement specifically permits such suits. So if you want the assignee to be able to sue for a previous infringement that occurred, please include that in your assignment agreements.
Neil, quick question from our audience. Karen asks, what about the clause, does hereby assign and agrees to assign? What do you think about that language?
That's fine. If it's got here, and I see that quite a bit actually, if it says agrees, usually in the opposite order, the seller or the transfer agrees to assign and does hereby assign, that's fine. But agrees to assign alone is not adequate.
Thank you.
Okay. Finally, Sega Technologies versus Pharmathene. This actually this involved a license agreement, but in different context from the previous three. The main takeaway, and there are several here, is that a letters of intent can be binding and legally enforceable, and that a statement that the parties shall negotiate in good faith may be affordable, and in some cases, although not usually, you may even get expectation damages, i.e. what you would have gotten if the deal had gone through. In this case, by way of background, Pharmathene had provided financing to Sega with the idea that the parties were going to eventually merge. Pharmathene would acquire Sega, and they had drafted up a letter of intent that said that basically, if for whatever reason the parties weren't able to agree on a merger, Pharmathene or Sega would exclusively license that very promising patent on a drug compound to Pharmathene. So Pharmathene figured we're either going to get the merger or the license, and the letter of intent set forth the terms that the license would contain in the event that there was no agreement, and of course had the language the parties shall negotiate in good faith. Well, it turned out that the merger talks fell through, and Sega got a major federal grant in the interim and suddenly started demanding better terms than were in the LOI. The court said the LOI is enforceable, and they can get the expectation damages. So basically, if you don't want a letter of intent to be binding, make sure it's very clear in that respect. Make sure it's written, not only that it says it's non-binding, but make sure there isn't language that could be construed in binding. General language is better. Disclaimers are good. And don't assume that merely saying this is a letter of intent makes your agreement non-binding. And don't half-heartedly throw in language, parties shall, without thinking about it, parties shall negotiate in good faith, because that may create a contractual obligation on your part. Okay. And I've indicated in this last slide a few reading tips. I'd say the article by Feldman and Price summarizing the lay of the land for bio and pharmaceutical companies and patent trolling is a particularly good 101 level article on this topic. And happy to answer any questions you may have in what little time remains.
Actually, looks like we're right against the end of our time period. We want to keep this as efficient as possible for our audience and thank them for their time, of course. As you can see on your screen now, you have contact information for Andrea, Neil, and myself. Obviously, you've heard today Andrea and Neil are terrific resources in this space. Feel free to reach out to them if you have any questions or if you have any insight that you'd like to clarify.